Attorney O'Brien, Desiree, just real quick, if you don't mind. I was talking to Desiree. Thank you. Then Attorney LaPrenzi, or Attorney Easter, you have about 15 minutes. Thank you.
Well, good afternoon, ladies and gentlemen. I feel like the last teacher of the day. It's seventh period, and last day before a holiday, and nobody cares what I have to say. Don't worry, it doesn't hurt my feelings. When I was in law school, I used to come out with all these grand ideas of how I was going to come in to a courtroom and I was going to wow everybody with my arguments and my statements, and I was going to convince you of my position in the case. As I've grown older, I realize that is absolutely the opposite of what I want to do here today. What I'm hoping to do, and don't take this wrong, is bore you. Because right now, I hope that what we did in the first week of this case, which was present all the evidence that you see on the table, present the witnesses and do all those things, I hope that before I even got up here, or Miss Easter got up there, that there was nothing more for me to say that the evidence didn't already say. And that really I'm just up here talking and you guys could go back there without me talking at all and find the defendant guilty. However, because I can't ask you that, I can't say, is there anything you want me to talk about? I have to talk just in case. So if you're one of those people that thinks you don't need to hear from me, I ask your indulgence, bear with me for a few minutes, because the person next to you may not quite be there yet. They might want to hear something. All right, so at this point in time, it's my job not to rehash everything that we've already talked about. Ms. Easter went over everything thoroughly. She did her job. Mr. O'Brien got up, he made his arguments, and now it's my opportunity to respond to his arguments. Now, he spoke for an hour. I have 15 minutes. The math doesn't add up, right? Now, we got our fair share. He got his fair share. But I'm just saying to you that I can't respond to what he said for an hour in 15 minutes. So I'm going to ask you to collectively use your common sense and reason, and you can make those arguments for yourselves, okay? Because there's a lot of things that were said that, Mr. O'Brien had to say. I know he was dancing around a landmine for an hour, being that phone call. Because we all know right now that the reason we are here today is because Erica Stefanko, and I said phone call, tape recording, because Erica Stefanko got herself recorded and said things that implicated herself in the death of Ashley Biggs. And we all know that. So let me lay some ground rules right here for you so we can get away from a lot of the stuff that Mr. O'Brien talked about. We all agree that Chad Cobb committed a violent act against Ashley Biggs. He is exactly where he needs to be and for as long as he needs to be. I don't think there's anybody that agrees with that. We all agree that everybody in this case has a motive. Cindy Cobb has a motive. Sure she does. What mother doesn't want her son out? Chad Cobb has a motive. What guy wants to spend the rest of his life in prison? Mike Stefanko, he has a motive. He is there taking care of all their kids. He wants help. And he wants his wife. Everybody has a motive, including the defendant. And hers might be the biggest one of all. The problem is that the motive they give at the end when Mr. O'Brien stood up is because she was being threatened or pressured about the kids. Over what? They had no power over her. None. No power at all. And by the way, who confesses to an aggravated murder to get along? I think Mr. O'Brien said, we've all been in that situation where we just said something that we really didn't mean just to kind of get the person out of my face. Well, if that's what she was doing, it didn't work because she still sat there and talked voluntarily for 3 whole hours. 3 hours. And not only that, she repeated herself multiple times, saying the same inculpatory things over and over and over again. Now, we're not going to tell you that there's 3 hours of great stuff in there. There's stuff in there about nothing. There's stuff in there about the kids. There's stuff in there about Chad Cobb being somewhat abusive to her. She alludes to the fact that maybe he did something to her. But at no time in 3 hours, not once, not a one time, does Erica Stefanko say, I didn't have anything to do with it. I didn't do it. I didn't do anything. I didn't make the call. I didn't drop him off. I didn't do anything, and he is lying. You will never hear that word one time. You will never hear her say that Chad Cobb lied. You will never hear her say that Cindy Cobb lied. She will never say it. She never did. So it's really interesting that the defense in this case is, don't believe anybody, including my client. Somebody's got to be telling the truth, right? And as we all know, everybody tells part truths. The difference is what are the circumstances in which those truths are being told? If you have a motive and you have a certain person you're telling those truths to, you might shade them a little bit in your favor. The thing is that Erica Stefanko did not know she was being recorded. And so when she made those statements, she had no reason to minimize her involvement or to exaggerate her involvement, more importantly. No reason whatsoever. It didn't help her. What they want you to think is the guy who is sitting in prison right now for the rest of his natural life, he will leave that prison in a box. That's how good his planning is. That's how good his ability to come up with a master plan is. He got himself in prison till he dies. And they want you to think that this guy sitting in prison came up with this master plan to have Mary Brinkman, his mother, and himself, all three of them, stay on the same page and able to set her up to be in that chair today so that he could have visitation, which, by the way, he already has. All we have to do is get her to lie and confess to a murder she didn't do, right? That's what they're saying to you. That's what you have to believe in order for her to be not guilty. You have to think she's a liar and that they set her up to lie. That's pretty good. I will tell you something else, too. Cindy Cobb, if you listen to that tape recording, Cindy Cobb, if she was a detective, I'd have a few words with her. Ms. Cobb, when she admitted to this plan, when she kept telling you, I did this, we planned this, why didn't you ask her what she was planning? Get the specifics. She doesn't do that. If she's out to get Erica Stefanko, why did she let her just talk? That's all she did is let her talk. She never asked her one real question about what happened that night. Not at all. They're not very good at this. You know who is? Erica. And you know how we know that? Because she told you, look, I've seen him do some crazy stuff. And he got away with it, as she laughs in the tape. You'll hear it. I've seen him get away with so many things, like getting that van out of the police station. And she says it with awe and revere. And here she is in a situation with a man she loves, and he wants his kids. Now, we all know her position with Grace. She'll tell you, she admitted to it. What she did to Grace was abhorrent. Giving the child dog feces, or what she believed to be dog feces, and she says it was abhorrent. She herself said that. She said she did wrong by Grace. GC. We know that. She told GC, don't love your dad so much. Now, keeping in mind, Mr. Stefanko says that she's a good mom. That, her own admissions suggest otherwise there. However, and I lost my train of thought because I got sidetracked with Mr. Stefanko. Well, let me go on. So in this plan, she tells Cindy Cobb, we did all those things. She talks about how he got away with all these crazy things, and she says he had a plan that was perfect. It was perfect. She talks about, he told me what my part was, he told me what his part was, and I executed my part and effing ate it up. But what's the problem? The problem is she did it perfectly. The plan was perfect. But what did she say? His part went awry. The reason I bring this up is because I want you to understand that they really did go there to kill them. She is not saying, or kill Ashley, she is not saying that it went awry, that he accidentally killed her, or that he didn't mean to kill her. Because we know that's not true, because they talk about keeping her skull. They talk about the fact that this is the only way, because the court system wouldn't work, that this can be done. She tells you that now, after Ashley's dead, now GC has a chance at a life. That wouldn't be the case if Ashley wasn't dead. So we know what their intention was. The part that went awry was this. Look at this kit here. If I was going to kill somebody, and I didn't want to leave evidence, what would I do? The last thing I want to do is leave DNA. And how do we leave DNA? Or actually pick up DNA? Is by getting bloody, right? Walking in and out of a room doesn't give you a high likelihood of getting DNA, but if you spill blood, now all of a sudden we've got problems. So what did they do? They had the plan. We tase her, no blood. She loses control. She falls down, no blood, no evidence. So then what do? Then we tie her up and we strangle her to death, no blood. And then we can use these same ties to lift her in her own car, take the car away, and dump her in a field that nobody will see. The corn was already plowed or planted and was growing, and there shouldn't have been anybody coming to that field for months, for at least a month, till that corn grew and was harvested. Unfortunately, it wasn't high enough. They didn't expect that somebody was going to see that car with the sun on. So the problem is that he raged. He got mad. And she talks about his rage. She talks about him being enraged at times and other times being calm. And this is the time he was enraged. And he drew blood. And once he drew that blood, now as soon as the police showed up, they knew something was wrong. Because if they had done it the way they had planned, the perfect way, they would have been out of there, no blood, no car, no Ashley. And they would have wondered, well, maybe she just left and went home. They would have had more time to get away. But that's not what happened. So what did they have to do? They had to alter their plans, and they had to go get cleaning fluids and go home and do that. They want you to believe that the fact that Chad Cobb called and said, only bring me clothes. He's the only one that's going to have blood all over his stuff. He's the one whose stuff is at the house with her blood on it. Erica was not, as you heard, there's no forensic evidence because she was never there during the killing. She had made the call and waited to pick him up or to follow him. Dropped him off and then waited to follow him and to take him home from that cornfield. Ladies and gentlemen, how much time do I have left, Judge?
A few minutes.
I think Ms. Easter went over very well what complicity is. And I will tell you that Mr. O'Brien had mentioned the fact that why didn't Cindy Cobb turn this in? Because she thought it had no value because she didn't think that Erica was really, telling the truth, or I guess didn't believe her. I think the same reason Ms. Cobb didn't turn it in, and this is the same reason that Erica said the things she said. They didn't understand the law of complicity. They didn't understand that you don't have to be the one going into the bank. You don't have to be the one that actually does the killing. You just have to be the one that helps the one that does the killing. When you see a crime, if you are a witness to a crime, you have three choices. Only three. One, you can do nothing. and watch the crime take place. 2, you could do something for good. You could call the police. You could try and step in and help or aid and stop and thwart the crime. Or you can help the criminal, right? So when that bank robber goes to the bank and you're somewhere outside and you're sitting in your car and you see him running out with the money and the mask and the gun, you can do nothing and sit there. You could call the police. You could try and chase him down if you wanted to. Or you could have him come and get in your car and take him away. Those are the only 3 choices you kind of have. Do nothing, do good, or do bad. As you think about the evidence in this case, every piece of evidence you think, which category does Erica Stefanko fit in? Did she do nothing? We know that's not the case. Did she do good? No. She didn't call the police while he was in that cornfield. No, instead, what did she do? She called Domino's to lure somebody to their death. That's complicity. Ladies and gentlemen, Ms. Easter said a few times, and she played a few times, in her own words. I know the defense is concerned that you're going to believe her words, and they don't want you to believe her words. It's a very difficult thing to get up and say, hey, listen, my client's a liar, don't believe anything she said. But the fact is that what she said, without knowing that she was being recorded, was that Chad told her, this is what we're going to do, and this is your part in it. I carry out my part in it, and I did what he told me, everything he told me. And I ate it up. She also said, this is the only way the situation is going to go away. And if everything had been told exactly as it happened, we would both be in prison. Now, ladies and gentlemen, if you believe her and you believe her own words, she is guilty as charged. My biggest concern right now is that thing we talked about in voir dire called sympathy and sentencing. So you've heard over and over what Chad's sentence is. And you may be concerned that because she didn't actually do the killing that you don't want to be heavy-handed. And you might let her slip away and go, you know, she didn't really do it, so I'm worried about that. Ladies and gentlemen, what you would be doing there is stepping on the province of the court. It's up to the judge to decide what a fair punishment is for her role in what happened here. Please do not let sympathy get involved. Do not worry about Ms. Stefanko. I know there's kids involved. We saw Grace. Grace lost her mother and her father. GC lost her mother and her father. And she's here testifying against somebody she called mom. And she seems to be doing well. She is surviving and thriving. The kids will survive. Don't worry about Erica Lyons' feelings. Just like, as she put it, she didn't feel bad about Ashley, not even the moments she went through before her life ended. Please do not let sympathy crawl in to your deliberations. And lastly, I'm going to tell you this. I told you in the beginning, please do not lose your common sense. Please do not contort the facts to match some narrative that you think that you want the outcome to be. Please use your common sense that God gave you, and when you listen to her words, please believe them. Thank you.
All right, thank you, Attorney LaPrenzi. Attorney O'Brien, would you take down the easel and tripod, please?
Certainly.
Thank you. Thank you very much. All right, ladies and gentlemen, just a few more minutes here. It is your duty to weigh the evidence carefully, to decide all the disputed questions of fact, to apply the instructions of the court to your finding, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your findings with intelligence and impartiality so that the state of Ohio and Erica Stefanko will believe that their case was fairly and impartially tried. Now, if during the course of the trial this court has said or done anything that you consider an indication of this court's view, you are instructed to disregard it. Now, your initial conduct upon entering the jury room is important. It is not wise to immediately express a certain determination or to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you decide you're wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide the case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced it is wrong. However, you should not surrender honest convictions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. This court will place in your possession the exhibits admitted into evidence and the verdict forms. The foreperson will retain possession of these records, including the verdict forms, and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote, and otherwise the authority of the foreperson is the same as any other juror. Until your verdict is announced in open court, you are not to disclose to anyone the status of your deliberations or the nature of your verdict. So after you retire to the jury room, and I'll talk to you about the details of that in just 1 minute, you will select a foreperson. That person has no more right or weight to his or her vote, but will chair the deliberations to see that they are done in an orderly fashion and that everyone is free to express his or her view. I will show you the verdict forms at this time. There's a verdict form for count 15, count 16, count 17, count 18, count 19, and count 20. And what will occur, it has the case number of this particular case, the name of the charge, and it states, we, the defendant, we find the defendant, Erica Stefanko, and it has a blank line, and you will write in either guilty or not guilty of the particular offense. And then it says, we render our verdict upon the occurrence of all 12 members and sign our names below this blank day of November 2020. And then there are 12 signature lines. So after all 12, and again, it takes all 12 to agree upon a verdict, you would sign that verdict form in ink, date it, and then advise my staff that you've completed your deliberations by using the buzzer, and we'll show you exactly where that is. And then when you come back to the courtroom, we will take those verdict forms and we will notify everyone that you have reached a verdict. But I will tell you, if you have difficulty or are unable to reach a verdict after careful deliberations, you are also to notify my staff, and we will address that issue at that time. With that, our alternates will be taken to a separate area apart from the other jurors. You will remain under the direction of our staff until a verdict is reached. Our alternate jurors will not accompany the jurors to the jury room or participate in deliberations. Unless directed by the court, the alternate jurors continue to be a part of the jury panel while the other jurors are deliberating. So you folks are required to follow all of my court orders. You are not permitted to discuss this case with anyone or amongst yourselves either. The three of you understand that? Okay, very good. Because if by some chance you are called in to deliberate, then you could never have discussed how you would have voted until such time as would be appropriate. Two more just procedural issues, and then we'll release you and you'll get started. And what we'll do is we will have you pick a 4-person, and then we can consider lunch for you all. But two things. The 12 always have to be together when you're deliberating or discussing. So let's say, for example, one of you has to use the restroom or needs to take a break. You do not discuss or deliberate while one is not in the room. Make sense? I know that may sound like common sense, but that's something that we have to be very careful of. So you discuss the case when the 12 are in the room together, okay? The other thing that we're going to do is we're going to have you go to your space where you've been in Judge McLaughlin's court, but you're actually going to deliberate in my courtroom. That way you folks are spaced out, and then that way you can view the exhibits here. We'll leave gloves, the sanitizing and disinfecting materials as well. And then my staff, though, will indicate to you, there's actually a buzzer in the traditional jury room that in case you need my staff or assistance, you can use that. We'll make sure that the doors are locked. So essentially, it's a jury room. It's just much larger than what folks think traditionally, okay? All right, so with that then, we'll make sure that you are provided with all of the exhibits and the verdict forms. And with that, I believe the court's in recess. Yes, anything from the state?
Can we approach about the instruction issue?
Sure.
Or question?
Point of clarification on the count of murder, count 18. The law, and it should read count 18, the defendant is charged with murder. As to this count, before you can find the defendant, you must find beyond a reasonable doubt that on or about the 20th day of June 2012 through the 21st day of June 2012 in Summit County, the defendant caused the death of Ashley N. Biggs as a proximate result of committing or attempting to commit kidnapping, aggravated robbery, or felonious assault. And so that will complete that instruction in its entirety. With that, anything further from the state then before we release the jurors?
No, Judge, thank you.
All right, thank you. Anything further from defense counsel?
Nothing further, Judge.
All right, thanks. So what we'll do is we'll have them step over to Judge McLaughlin's court, and then they can actually pick a 4-person then. I will then permit them to have a lunch break so long as we track that time and they're not to discuss the case, or if they want to bring lunch in as they deliberate. You can let me know that, and then what we'll do though is once we have everyone cleared here, then we'll have them begin their deliberations, okay? All right, thank you. All rise. Okay, I think they are out. Is there anything the state would like to put on the record at this time?
No.
No, Your Honor.
Okay, hold, thanks, Desiree. Anything further from the state?
No, Judge, thank you.
Okay, anything further, Attorney O'Brien?
No, Your Honor.
All right, very good, thank you. for them to be able to watch or listen to that audio.
You can do it here.
You said you had that jump drive, right, Attorney LaPenzi?
Actually, Chrissy has it.
Okay. Okay, fair enough. Okay, very good. All right, and then you folks, you made sure, Attorney O'Brien, that any of the information on those jump drives is just related to this case, right?
I have, Your Honor.
Okay. Okay.
I'll have you double check to make sure that I have everything right, that I'm not accidentally putting something that doesn't belong in.
Sure.
I'll have you do the same thing. Don't leave it, be willing to come get together so we
Yeah.
can look through them and make sure that I have everything.
Yeah, sure.